Hey, welcome back into Eye on Agriculture. I'm Britton Rucker. As 2024 begins, it's good to look back at the most important developments in agricultural law and tax from 2023. We're joined now with Roger McEowen, Professor of Agricultural Law and Taxation at Washburn University, to walk us through some of these. As always, Roger, it's a pleasure talking with you today.
Well, thanks for having me, Britton.
All right, Roger, kicking off the discussion, we have to talk about labor disputes in agriculture.
Yeah, there was a big case in 23 that went to the U.S. Supreme Court, and they issued an 8-1 decision that said when workers strike, when a perishable commodity is involved, when they strike, the point where it becomes economic damages in terms of the timing of the strike in relation to that perishable commodity, then the employer does not have to go through the administrative channels. They don't have to go through the National Labor Relations Board and go through all that administrative process. They can go straight to court to protect their property. And I think that's relevant when we talk particularly about fruits and vegetables, unionized workers. If they time a strike in such a manner that it's going to essentially destroy that product, then the company can go straight to court. It's a tort case and not a labor case.
Now, another 2023 development involved the application of the swampbuster rules on a South Dakota farm. Now, what is that if people are unfamiliar with this?
Well, swampbuster came in the 1985 Farm Bill, and it says that if you have a wetland as defined under the USDA rules, now not for purposes of WOTUS, that's EPA and that's Corps of Engineers, but for purposes of the Farm Bill, if you have a wet area that meets the definition of a wetland, you cannot drain that and farm it and receive farm subsidies. Well, what happened in this situation is back in 1936, the farmer's father planted a tree belt to keep snow off of the road and out of his fields. And what happened is it worked. And as the spring thaw would come, the snow would melt and it would puddle, create a puddle occasionally, in some years it did, in the middle of the field, less than an acre puddle. And the USDA came in and said, well, that's a wetland, you can't farm it, and if you do, you're going to lose all your subsidies. Well, he came up with other evidence that showed that it didn't meet the definition of what a wetland is for purposes of swampbuster, and the USDA refused to reconsider its decision when the statute seems to indicate they're supposed to. Now, he's lost so far in the courts, but there's a request now that's been filed with the U.S. Supreme Court to hear the case. So we'll have to see in 2024 whether they decide to take the case.
And Roger, abandoned rail lines that are converted to recreational trails have been controversial, as we discussed.
Yeah, and we had a significant decision by the Federal Circuit Court of Appeals in 23 that says that you may actually have a taking of private property from the landowners that own the land adjacent to that corridor when it's no longer used for a railroad use. And instead of it reverting back to the adjacent landowners, some trail group comes in and creates a recreational trail. The answer in this case, it was a taking, but that's going to depend on state law, and it's going to depend on the language of the original grant to the railroad. If all the railroad got was an easement, and state law says that that needs to revert back to the adjacent landowners when the railroad terminates, then you've got a taking if it doesn't.
All right, Roger. Well, thanks so much. We'll check back in with you over the next couple of weeks as you'll be working through some of the biggest developments of last year in ag law and tax. Roger, again, thanks so much for coming on. And everyone, stick around, and Ag will be back after the break.